G'day everyone and welcome to Laws 11061 Contracts A. This is the last topic, topic 12, the Doctrine of Privity. My name's Anthony Marinac, and by this point in the semester you're all starting to get sick and tired of the sound of my voice. The good news is that we've saved the most complicated, most unusual and most difficult to understand week until last. Let's crack on with it. What we're going to do this week, we're going to talk about the Doctrine of Privity, and that's going to put us to the point where you can all astound and stupend me with the quality of your exam papers. Once we've talked about privity, we're going to show how Queensland law deals with the doctrine. Now, it is wonderful to live in Queensland, not just because we have the best beaches and the nicest cities in the entire of the country, but also because we have the only sensible approach to the Doctrine of Privity. Unfortunately, we are also going to have to talk about the common law approach to the Doctrine of Privity, because some of you, sadly, are not in Queensland, and some of you will not be practicing in Queensland. And of course, we'll all from time to time have occasion to be applying Commonwealth law. So let's talk about the Doctrine of Privity. We'll talk about the sensible Queensland approach, and then we'll talk about the somewhat less sensible common law approach to the doctrine. Fair warning up front, look, this bit of the course is complicated, and so if you find that you listen to this lecture a couple of times, you read the notes a couple of times, have a look at the key cases, and you're still not quite getting it, you're sure as heck not going to be on your Pat Malone. It is not unusual at all for people to find the Doctrine of Privity quite difficult to get your head around. So let's go in with that expectation, and I'll do my modest best to try and explain it to you as well as I possibly can. So let's start. What is privity? Well, way back when during this course, way back when we were still looking at formation of contract, we talked about the idea of consideration, and I introduced you to the concept of nudum pactum. The idea of nudum pactum is that if you haven't given any consideration for a contract, then you've really got no basis upon which to sue anybody. You remember the discussion that we had where I talked about offering two friends the opportunity to come to dinner at my place, and one of my friends has paid me $20 to help with the cost of dinner, and the other of my friends hasn't. They're just going to show up for dinner. And then I decide at the last minute I'm going to cancel dinner. Now the friend who hasn't paid anything, well, they've really got no cause to be anything other than mildly disappointed, have they? But the friend who has paid me something, they're entitled to turn around and say, "Hey Anthony, yeah, okay, fair enough, so we're not going to have dinner, but what about that $20, mate? Can I get it back?" Okay, so you can see that if you've given consideration for a promise, it puts you in an entirely different position to a person who hasn't given consideration for a promise. And from that, we took away the rule of contract law that only a party to the contract, that is, only someone who has given consideration, is going to be able to enforce the contract. Now, back when we were studying formation, that rule seemed simple enough. Now it gets a little bit more complicated. You see, we ask the question, what happens if a contract is made for the benefit of a third party? What happens if you and I make a contract where I pay you to provide services to my mother or my friend or my son or my sister? What if you fail to provide those services? Is that third party entitled to sue you? Well, as a general starting point, the Doctrine of Privity would say no. The Doctrine of Privity would say they are not a party to this contract. They have not provided any consideration for this contract. To them, the provision of service is nudum pactum. They've given nothing. So how should they, on what basis will contract law allow them to enforce the contract? That's the Doctrine of Privity in a nutshell. The Doctrine of Privity says you must be privy to a contract. You must be part of the contract. You must have given consideration if you're going to enforce the contract. We understand this by looking at three key cases, and you need to understand these three cases. And look, the doctrine of privity may well not come up in your Contracts A examination, but it's quite likely to come up in the course of Contracts B, and you will be expected to understand these three cases. The first one we've met before. This is Dunlop Pneumatic Tyre and Selfridge and Co. Now, I'm sure that most of you will remember at least the basic outline of those facts, but let me go over it again very briefly. The Dunlop company had a contract with a company called Due, which was essentially a price maintenance contract. It said, we'll sell our tyres to you, but you'll make sure that you don't discount our tyres below a certain level. The tyres are to be sold at least a certain price. And Due said, yep, no worries, we'll sign that contract. And then Due on-sold the tyres at the correct price to a company called Selfridge. And that company, Selfridge, started discounting the tyres. And they discounted the tyres below the level that Dunlop and Due had agreed was appropriate. And so Dunlop sued Selfridge. And the court said, nope, not going to allow this to be successful because, Dunlop Company, you have no contract with Selfridge, you have only a contract with Due. Due has then sold on the tyres to Selfridge without imposing a price maintenance agreement on Selfridge. So Selfridge has not failed to comply with any contractual provisions that apply to it. You have no contract with Selfridge, so how can you enforce the contract on Selfridge? How can you make a contract with Due with the result that there are obligations on Selfridge? That doesn't make any sense. So you can see in that case Selfridge was not privy to the contract, and because they weren't privy to the contract, they couldn't enforce the contract, and the contract couldn't be enforced against them. They simply weren't part of the action. Second case we need to look at is Cools and Bagot's executor and trustee. Now in this case what happened was Mr. Cools owned a quarry, and the quarry was it was his, and he let the rights to it. So he owned the quarry, but he didn't actually conduct the quarrying activities. He let the rights for that. He then went and died, which in most legal circumstances is not a particularly advantageous thing to do. But he made a contract with the people who were operating the quarry that they would operate the quarry and provide the benefits of that operation, so the royalties, both to himself and also to his wife, Mrs. Cools. After he died, the question came up, could Mrs. Cools enforce the contract? Was it possible for her to say that she should continue getting her royalties, or should the royalties all be paid into the estate of Mr. Cools and then distributed by the executor and trustee, which is Bagot's? And the court said, sadly, that Mrs. Cools had no basis on which to enforce the contract. Okay, she had she was not a part of the contract. She had given no consideration, and therefore there was no basis for her to receive any payments, because the contract had been between Mr. Cools, now dead, and the company which was quarrying the stone. So if he's now dead, how can Mrs. Cools start making any claims on that contract? She was never a party. Most people, when they see this Cools and Bagot's case, see it as essentially the law working a great injustice. And it was really cases like Cools and Bagot's that forced both the legislatures and the common law to start looking again very closely at the idea of privity and saying, look, here we have a doctrine which makes a great deal of sense. I mean, it does actually make sense that you shouldn't be able to enforce a contract if you haven't given any consideration. And yet at the same time, this is a doctrine that is really clearly working an injustice. I mean, any common sense of justice would say to you that Mrs. Cools should have been entitled to continue receiving her royalties from the quarry, that her husband's death shouldn't have denied her the income which was properly hers during the course of his life. Any sensible view of justice would see that. But the application of the doctrine of privity meant that that couldn't happen. So we have this doctrine that is starting to create injustice. What do we do about it? Well, the court's got the opportunity to have a look at it again about 20 years after Cools and Bagots, when the case of Trident and McNeese came up in 1988. Now this case has got a fairly boring set of facts, and they're also a fairly complicated set of facts, so try and follow with me just for a minute. Trident Insurance, obviously, as the name suggests, was an insurer, and they provided essentially what amounts to workplace health and safety coverage for a company called Blue Circle. Blue Circle, in turn, hired McNeese. McNeese was a subcontractor, and McNeese in turn hired a worker. So we've got a worker who works for McNeese. McNeese is subcontracting to Blue Circle, and Blue Circle has an insurance policy with Trident. Okay, can you see the links there? Now this worker goes and gets himself hurt. And the worker turns around then and says, I want to rely on the insurance contract between Trident and Blue Circle to pay out my insurance claim. Because the insurance contract between Trident and Blue Circle was meant to cover all workers on the site. The worker said, well, I'm a worker on the site. I've been injured in the course of my duties. Here is an insurance contract that is supposed to cover injuries of this type which are caused to people like me on the worksite. Oh, I'd like to make a claim, please. Now, on the face of it, that sounds pretty sensible. Trident turned around and said, well, no, hang on. We have a contract with Blue Circle. We don't have a contract with McNeese, and we certainly don't have a contract with this individual worker. So, hey, Doctrine of Privity, guys, that says that you don't have a contract with us. You have given us no consideration, Mr. Worker. Therefore, why should we pay out on your insurance claim? Now, this question came up to the High Court, and the High Court, frankly, made a mess of it. With all due respect to their honours, they made a serious mess of it. Because what we ended up with was about 5 different ways around the Doctrine of Privity. Because their honours clearly saw that it would be unreasonable and unjust for Trident to be able to avoid its responsibilities to pay the workers' compensation. But they weren't able to come up with a consistent or coherent doctrine to show why the privity rules shouldn't work in this particular case. We're going to come back to Trident and McNeese when we look at the common law rules of privity. But now at this point, we've gone through those basic 3 cases, and what we can see from Dunlop and Selfridge, from Cools and Bagots, and from Trident and McNeese is first the basic operation of the doctrine, that if you are not privy to the contract, if you're not a party to the contract, if you've given no consideration, then our starting point is you can't sue anyone. You cannot enforce the contract if you're not a part of the contract. But then we've seen, particularly in Cools and Bagots and again in Trident and McNeese, that this doctrine, which sounds sensible, is capable of working terrible injustice. I mean, Mrs. Cools sensibly was entitled to continue the income from the quarry that her husband had owned. And the worker in Trident and McNeese had been injured on the job and realistically should have been entitled to an insurance payment to make good the harm that he had suffered in the course of his duties. So we have this doctrine, and it's not working. It's perpetrating an injustice. What do we do about it? The rest of this lecture is actually not about the Doctrine of Privity at all. It's actually about the mechanisms that the law has found to moderate the doctrine and to stop it from applying in the unjust sorts of ways that we see in Cools and Bagots and Trident and McNeese. Let's start in Queensland. Let me tell you, in Queensland, the rules are awesome. There's one single provision that you need to know. That's it. Just one provision, Section 55 of the Property Law Act 1974. The way that works is that we divide the contract up into 3 parties. There's the promisor, the promisee, and the beneficiary. Now, we've already met the promisor and the promisee right the way through this course. The promisor and the promisee are simply the two parties to the contract. Each of them has obligations, each of them is given consideration, each of them can enforce the contract. But in this case, the promisor is not proposing to give the benefit of the contract or to perform the obligations under the contract for the promisee. The promisor is proposing to perform those obligations for the beneficiary. So this is where you and I make a contract whereby I pay you to mow my mum's lawn. Okay, so you're the promisor. You're promising to pay to mow the lawn, but you're not promising to mow my lawn, even though I'm the one paying you. You're promising to mow the lawn of a third-party beneficiary. Now, in Queensland, if that beneficiary accepts the contract, and they can do this in any number of ways. They can do this in writing, they can do this by their conduct. If they accept the contract, they can enforce it. It is just as though they had given consideration. But they have to accept the contract. So if I made a contract with you to mow my mum's lawn, and she said, bugger off, I'll mow my own lawn. I don't want anyone turning up here to mow my lawn. Well, she doesn't have to accept the contract. You see, it can't be imposed on her. She can't suddenly become compulsorily a party to a contract that she never wanted any part of. But if she does accept the contract, then she can enforce the contract. And by the same token, if there are any obligations that might attach to her from accepting the contract, then those obligations would become binding upon her as well. So essentially the beneficiary, by accepting the contract, they become a party to the contract. And that's it. That's the whole Queensland answer. Now, if you're a true believer in consideration, if you're a true believer in the doctrine of consideration, well, point number one is you probably need to go and get a life. But point number two is that if you're a true believer in the doctrine of consideration, you're going to find the Queensland answer to privity a little bit disconcerting. Because here we have a person who is given no consideration suddenly being able to enforce a contract. But realistically, common sense has got to prevail at some point. And we have a situation here where the Queensland rules are pretty darn consistent with our general philosophy of contract. Because you're still requiring an exercise of free will by the beneficiary. The beneficiary can't find themselves trapped into a contract they never wanted a part of. What they can do is say, I am going to accept the benefit of this contract, and I'm going to accept it on the basis that another party has provided consideration on my behalf. Okay, so the promisee provides the consideration. The promisor, well, they're getting the same money for the same job regardless of whose lawn they mow, and the beneficiary ends up with the benefit under the contract. Let's apply the Queensland doctrine to the three cases that we've talked about. Let's start with Dunlop and Selfridge. What if Dunlop and Selfridge had happened in Queensland? Well, Dunlop would have made their contract with Dew to say, we want to have a price maintenance agreement. Dew would have made their contract with Selfridge. Dunlop would have said to Selfridge, we're going to sue you for dropping the price. Selfridge would have said, no, I'm the beneficiary under this contract, I'm the third party, and I don't accept the contract. I don't accept the obligation upon me to maintain the price. And so Dunlop's case would have failed. No great injustice there, because Dunlop could have protected their position by making part of their contract with Dew that if Dew on-sold the tyres, they would have to impose a similar price maintenance agreement on whoever they were selling the tyres onto. So there's no great injustice there. So we can say that Dunlop and Selfridge works okay under the Queensland doctrine. Now let's move on and have a look at Cools and Bagots. Very simple. Mrs. Cools would have been able to turn around and say, I'm the beneficiary under this contract. I accept the contract. Therefore, please continue to pay me my money. Perfectly just outcome. What about Trident and McNeese? Well, the McNeese company and then the worker would have been able to each say, well, we are the beneficiaries under this contract. We accept the contract. And therefore, as a result, we accept whatever obligations we might have been under. For instance, might have been an obligation to wear a hard hat on the work site or to follow workplace health and safety practices. We accept those obligations and we would like to sue now and get our workers' compensation insurance payment. Perfectly sensible, justified outcome. So, hallelujah for Queensland statute law. If a question of privity comes up in the exams or in the assignments, it's almost certain that it will be occurring in Queensland, and it's almost certain that you'll be able to answer it simply by applying Queensland Doctrine of Privity. If you want to really impress me, you can then go on and apply some of the common law doctrines that we're going to talk about in the next slide. And now, before I click on to the next slide though, I want to make it really, really, really abundantly clear. This is the law in Queensland. Privity is the law in Queensland. I'm about to talk about a bunch of common law exceptions. Those exceptions almost never apply in Queensland. They might possibly apply in a situation where a beneficiary refused to accept a contract but then wanted to sue on it anyway, but that's a pretty out there situation. Don't go assuming that the Queensland statutory approach to privity is part of one suite of measures with the common law exceptions. If you do that, you'll get all mixed up and all over the place, and yet again I will have to draw a sad little face on your exam paper whilst giving you a poor mark. So, presuming we're all clear on that, let's go to the common law. This is what happened as a result of Trident and McNeese. You remember I said that the High Court really, in my view, made a mess of Trident and McNeese. Well, what happened is that each of the judges obviously saw that there was an injustice, and they all looked for their own way around it, and most of the ways around it came from equity law. Now, we've talked about equity law from time to time this semester. I've talked about how it commenced with the Chancery, the Court of Chancery in the United Kingdom in around about the 14th century, and that it was based on old precepts of ecclesiastical law, and in particular the notion of the law of the court as a court of conscience. A court that could look to justice first and foremost. Now, you're going to learn a lot more about equity law when you study the subject called, strangely enough, equity law, and I don't want to try and get too far ahead of that. But equity law includes a number of concepts which the court decided were very helpful to try and resolve the issue of privity. The first one of those is what we call agency. Now, an agent is someone who can act with the legal personality of another person. So let's say I have a relative who has a car accident and ends up unable to make their own decisions. Okay, they've had a severe brain injury, they're unable to make their own decisions, but before they had this accident, they gave me an enduring power of attorney. That enduring power of attorney makes me an agent for that person. I am able to enter into contracts as though I was them. I am able to make all sorts of legal decisions as though I was them. Now, one of the answers that the court came up with in Trident and McNeese was to say, well, what if we assumed that the key company, Blue Circle, was acting as an agent for all of the workers? So if Blue Circle was acting as an agent for this worker who got injured, then we could say that the worker actually was a party to the contract. It's just that instead of doing it personally, they were a party to the contract through their agent. Now, that has a certain amount of common sense to it, except, of course, that I can't see where the worker ever actually agreed that Blue Circle was going to be his agent. And usually, agency would require that sort of a voluntary concession of rights. Otherwise, the worker should have had the right not to have Blue Circle as the agent. He might have said, no, I want to go with a completely different insurance company or a completely different scheme of insurance. I'm not happy with this. Do you see how the worker never had that opportunity? So personally, I find the agency argument, which was raised by the High Court, a bit unconvincing. The second common law exception is what we call trust. Now, Trust is very similar to agency. If you are a trustee, then you are holding rights, usually possessory rights, but not always possession of goods. It can actually be rights to take a legal action. You're holding those rights on behalf of another person. Okay, so if my sister were to die leaving her young children behind and she was to make me the trustee for those children, then everything that they would inherit under her will would actually come to me, but I would be required to use it only for the benefit of those children. That's the basis of a trust. If we apply that in a privity situation, if we apply that to Trident and McNeese, the court could say, well, really, Blue Circle was acting as a trustee for the interests of all of the workers on the site, and therefore it's not like agency where the workers would be required to volunteer to be part of the agency, because that is the beneficiary is not required to volunteer to have someone hold something in trust for them. So that problem's out of the way. So we could say Blue Circle was acting as a trustee for all of the workers on site, and therefore there's no problem. The only thing is that all of this is a bit artificial, isn't it? I mean, in order to be a trustee, you would normally expect to actually know that there was a trust. You would expect to actually know that you were a trustee. That's not always the case. There's a rather complicated little doctrine called the Doctrine of Constructive Trust, which I'm not going to go through right now because it's really something that you'll go through towards the end of your equity law subject. But it really doesn't have the ring of truth about it, does it? The idea that we construct this idea of a trust. So then the High Court came to a third way around this, again from equity law. And this is called unjust enrichment. Now, the doctrine of unjust enrichment within equity law says that if somebody gets a great big windfall gain, and it's clearly unjust that they do so, then even if the strict reading of the law is on their side, well, we're going to take the enrichment off them anyway. So how do we apply this to Trident and McNeese? Well, you could say, clearly, Trident were in an unjust enrichment situation because they took the premiums on these policies. And if they took the premiums on these policies whilst all the time knowing that they were never going to have to pay out on any injuries to any workers, because those workers would not be Blue Circle's workers, they would be the employees of subcontractors of Blue Circle, well then that's pretty unjust, isn't it? It's unjust enrichment for the insurance company to say, we're going to take the money off the company, but we're going to do so knowing that even if the sorts of accidents that are contemplated in the insurance policy happen, even if it's exactly what's contemplated in the insurance policy, we're not going to pay anyway, because we know we're going to be able to hang them with the Doctrine of Privity. Now that's probably, in my view, the best answer that the High Court came up with, because the High Court's simply saying this is unjust and therefore we won't allow it. But in that case, you would have to rely on there being some sort of initial injustice. What happens if we apply unjust enrichment to a Cools and Baygot situation? You see, when the quarry operator made a deal with Mr. Cools to pay the money to Mr. Cools and his wife, the quarry operator never had any concept that they would become unjustly enriched. What they were planning to do was quarry the stone from the quarry and pay their royalties to Mr. Cools and whoever else he should nominate. And then Mr. Cools went and died, and the quarry operator has turned around to his executors and said, well, we're still quarrying our stone here and we're still prepared to pay the royalties that we've been paying right the way along, and we just want to know who to pay them to. Do we still pay some to Mrs. Cools, or do we pay the whole lot to the estate? So you can see in that situation, the quarry operator, which is the other party to the contract, they're not getting any unjust enrichment. So in that case, the doctrine of unjust enrichment wouldn't have helped, would it? Mrs. Cools would still have ended up in a situation where she wasn't entitled to any of the benefit that her husband had intended to provide her, when he signed the contract with the quarry operators in the first place. So unjust enrichment's not a bad approach in a Trident and McNeese situation, but it doesn't get us there as a full answer to the problem posed by the Doctrine of Privity. The final way around it is the idea of collateral contracts. Now, we've talked before also about collateral contracts. A collateral contract occurs when entering into one contract is the consideration paid for the commencement of another contract. So in other words, I make a deal with you that I will tutor you in law if you enter into a contract with my mum whereby you mow her lawns. Okay, so you making the contract with my mum is the consideration that you're giving for me giving you tutoring in law. They're two separate contracts, but they're inextricably linked, because entry into the one contract is consideration for entry into the other. Now you can see how cool this could be for trying to work out a privity situation, because what you could say in a Trident and McNeese situation is, well, we're going to say that there was a collateral contract between the worker and Blue Circle to perform work on the site, and that the entry into that contract was consideration for the operation of the main contract of insurance. So in other words, we will insure you if you work for us on site. Okay? Only thing is that, again, it's all very artificial, because where is this contract? If we go back to our stages of contract formation, there's probably no problem with capacity, but can we honestly say that there's intention to create legal relations here? Can we honestly identify where the offer and acceptance happened? Can we honestly say that these parties were ad idem in relation to the collateral contract? Can we honestly say that the contract was sufficiently certain and complete? So you see, it starts to fall down, because the collateral contract in this case is just an invention. It's just a legal invention. It doesn't actually exist. So how can you sue on a collateral contract that barely even exists? So you can see these common law exceptions provide some general ways around the idea of privity, and they've led, but their failure to do so comprehensively has led to some commentators saying that the doctrine of privity in Australia is now virtually dead. Well, I'm not sure that that's the case, to be honest, because you still have to be, in order to enforce a contract, you still have to have either given consideration, or you have to be able to show that you were an intended beneficiary under the contract. So I think the doctrine of privity is still there. I think, however, that now that we've had a look at these common law exceptions, you can see how fantastic the Queensland Answer is. How utterly beautifully simple the answer is to say, well, we're going to recognise that if the contract is made for the benefit of a third party, that third party is a person, we'll call them the beneficiary, and we'll create some rules for when the beneficiary is going to be able to enforce the contract. And those rules are pretty simple. They say, if the beneficiary accepts the contract, then they're going to be able to enforce it. Absolutely wonderful approach to legislating. Hey, guess what? That's it. We're at the end. Because we had our skills week back in year 7, back in week 7, we don't have this week as a review week. No doubt we will be able to spend some time during tutorials this week reviewing things ahead of the take-home examination. Just a couple of words from me about take-home examination before you go and have a bash at it. Don't underestimate take-home exams. Okay, people think that because you're not going to be in an invigilated examination situation, there's no need to take it that seriously, and a lot of people put them off and end up doing the take-home exam in the same 2 hours that they would do if they were sitting in an invigilated exam room. Don't do it. Okay, our expectations are much higher from a take-home exam. We expect you to be able to show us a great deal more depth of knowledge than is possible for someone who's sitting there panicking their heart out in an invigilated exam. Take the full 24 hours, take the 24 or 48, take the full time. Submit within the last hour or so before the time is up. Let your family know that you're going to be busy for that period of time. Use every minute to research, to go through the notes, to follow the sorts of patterns that we talked about when we did skills in week 7, so that you can really demonstrate to me that you have gotten your head entirely around the materials for Contracts A. Let me tell you, I want to give you a great mark. What I want you to do is give me as many excuses as possible to give you that great mark. So this week we've talked about the Doctrine of Privity. We've talked about the fact that Queensland is awesome and the Queensland approach to the Doctrine of Privity is awesome. And we've also talked about the various approaches that the common law has made to the doctrine, which is all over the place. You do need to understand those common law doctrine principles, but please feel free to bring the same critical approach to them that I have. Look, I really hope that you've enjoyed Contracts A this term and that I haven't scared too many of you off and that you'll be back for Contracts B next term. I started this lecture series by acknowledging the fact that many of you wouldn't want to be here, that this is not a subject that many of you would have a great deal of enthusiasm about. And look, I hope that has changed for some of you. And for those of you who it hasn't changed for, I do hope that the way that we've been able to work through this semester together has made the trip just that little bit less painful. I do hope you go well in the exam. Enjoy the break, and I'll look forward to catching up with you all again next term for Contracts B.